Hi, I'm Rachel Alters with the law firm of Dell & Schaefer, and today I'm going to talk to you a little bit about a case out of the Northern District of California that Dell & Schaefer didn't actually handle, but it's a very good example of how Hartford Insurance Company is performing these cursory reviews and terminating benefits that really shouldn't be terminated. This is a case called Stout versus Hartford, was also against Amazon.com, who was the plaintiff's employer. In the case, what happened was this was a plaintiff who was suffering from Sjögren syndrome. Sjögren syndrome is an autoimmune disorder that basically can affect you physically and cognitively. You can have fatigue, you can have pain, sometimes you have memory problems, sleep disorders, all kinds of things. And this woman was suffering from this, and at work she was noticing she was making a lot of mistakes. Her employer was having an issue with the mistakes she was making, and she was also suffering from fatigue while she was trying to perform her job at Amazon.com. So she applied for her disability benefits, and what happened was Hartford decided not to approve them after they had hired several experts to do paper reviews. This is what insurance companies tend to do. Instead of having a claimant examined or having them interviewed by a doctor, what they'll do is they'll review the medical records and make a determination that they don't believe that this claimant is disabled. And that's what happened in this case. The court actually was very unhappy with Hartford's performance of their review. The court actually, in the decision, was clearly kind of slapping Hartford on the wrist for failing to do any kind of examination of this client or this claimant, failing to consider the fact that her cognitive and her physical conditions were preventing her from doing her job. They would just look at the cognitive alone and say, well, cognitively she can handle working in her occupation, or they'd look at the physical alone and say, well, the physical wasn't quite so bad, she could probably work, instead of looking at them together as physically and cognitively she was having all different issues. They should have considered those together in how they affected her ability to perform her job. So that was the first thing the court had an issue with. And the second thing, like I said, is that they only did a paper review. They had several physicians do paper reviews and said, well, you know, we looked at her medical records, we don't believe that she's disabled, she can go back to work. The judge says, no way, that's inappropriate, and he cited a bunch of case law in California that stated it's inappropriate not to have the claimant examined if you're really going to do a proper review. They also conducted surveillance on her, trying to say that, well, you know, we got her on videotape doing a couple things that prove that she can actually go to work. Where in actuality, in this case, they conducted about six days of surveillance on her and only got her for about 2 hours out of her house. And most of the time, I think she was either grocery shopping or she was at the dentist. So they really couldn't use any of that in the judge's mind to show that she was able to do her job 40 hours a week with any reasonable continuity. So that was another problem that the court had with the case. And you know, in general, the court was upset because they hired these doctors who were giving opinions on functional capacity evaluations that were done on this claimant, where the physician that performed the functional capacity evaluation said there's no way she could work physically, mentally, she has all these issues, and their hired doctors would say, well, we disagree with this functional capacity evaluation, we think she can work, but they weren't giving actual specific reasons as to why they disagreed. So the court had a lot of issues with Hartford's performance. They basically were slapping Hartford on the wrist saying, this is not going to happen, this is unacceptable, and the court at the end of the day reversed their decision to terminate benefits. They said to Hartford, the motion for summary judgment was granted in favor of the plaintiff. Hartford had to pay this claimant for 24 months of her own occupation. And there's a difference between the definition of your own occupation, and then after 24 months it'll switch to whether you can do any gainful occupation. The court in this case wasn't comfortable granting any benefits for any occupation because they had said that Hartford hadn't done a review for the any occupation stage, so they were going to remand it back to Hartford to make that determination, but they did grant the 24 months of any gainful own occupation, and they also gave attorney's fees and costs, and it really was a windfall for the plaintiff, and made an example out of Hartford that can be used in cases down the road when Hartford decides to do a cursory review of a case and not perform a physical examination of the claimant. If you find yourself in a situation where your insurance company has wrongfully denied your benefits, whether it's Hartford, such as in this case, or any other insurance companies such as Unum, Cigna, MetLife, feel free to give me a call at Dell & Schaefer, and I will do my best to assist you.